I think that what I have learned from different places, I want that those things to be utilized for my own state, and that is why I want to serve there.
Okay. So ये बताइए, आप लॉ करने के बाद काफी टाइम आपको भी जुडिशियल सर्विसेज में आने में लग रहा है.
Yes,
तो ये जो बीच का टाइम है जिसको हम कहते हैं कि अनएम्प्लॉयमेंट,
yes,
ये एक अनएम्प्लॉयमेंट का सिचुएशन है.
yes,
सो कहीं आपको कॉन्स्टिट्यूशन में, अंडर इंडियन कॉन्स्टिट्यूशन, जहां पर आपको बहुत सारे फंडामेंटल राइट्स आर गारंटेड, देयर आर सो मेनी डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसीज फॉर गवर्नमेंट टू. So is it possible to claim right to work as a fundamental right, or you can claim or you can file writ petition for employment?
Ma'am, as it is contained in Article 41, that is right to work. But ma'am, as it is directive principle, we can't claim it as a right. If state reaches on that situation, that it is on state's discretion that it can provide, but it is not enforceable by courts.
Okay, very good. अच्छा ये बताइए, क्या आप अपने मदर फादर से मेंटेनेंस क्लेम कर सकती हैं because you are not employed?
Ma'am, as I am a major now, I can't claim maintenance from my mother father.
Okay, where it is mentioned?
Ma'am, it is mentioned in as those persons have been mentioned who can claim maintenance. So a major daughter who is able to maintain herself, she has no right to claim either in CRPC or in the Hindu Maintenance Act.
Okay, ma'am, आप.
Okay, so Priyanka, are you comfortable in English, talking in English?
Yes,
ठीक है,
yes,
आप दोनों लैंग्वेज में बोल सकती हैं वैसे. So I just would like to ask you, you said that you have reached an interview in 2018 in Bihar Judiciary. So
yes,
I'm sure you must have reflected on, you know, like the question which has been asked in the interview and the answer which you have given. So have you found out anything where you think you went wrong? आपको ऐसा क्या लगा कि क्या चीज रह गई जो मुझे अपने में इम्प्रूव करनी चाहिए, जो इस बार आप थोड़ा जिस पे ध्यान दे रही हो? We would like to listen. I think Rama ma'am also would like to know about that.
Yes, ma'am. First thing is that I was not prepared with the case laws based on Article 21. That question was asked to me about Article 21. I could not answer that question. And second problem with me was that I was not so fluent in communicating my answers. These two drawbacks were with me in last time.
Okay. So are you have gone through all the recent cases since you have realized that कि last time आपने कहीं ना कहीं case law revise नहीं की है? So let me ask another question. So can you tell us some leading question on right to privacy?
Yes, ma'am. This right to privacy comes, first case on it was Khadak Singh versus State of UP. And recent case we have on a right to privacy is J.S. Puttaswamy, Justice J.S. Puttaswamy versus Union of India.
Can you tell us a little bit about how the right to privacy, you know, concept has been recognized in Puttaswamy case? थोड़ा बहुत हमें idea बताइए इसमें कैसे कोर्ट ने कहा?
Ma'am, it was held that as we have a right to know under Article 21, we have right to know, but also we have right to privacy. That also it has been recognized in other aspects, like when our information is shared on any social media or such things, then we have right not to disclose those information when they have become irrelevant. To right to forget also has been recognized here.
Okay, so it is also recognized right to forget. So in case if your privacy is violated, you can go directly to the court based on this judgment or based on Article 21. Yes or no?
Last sentence, ma'am.
I'm just asking, in case if your right to privacy has been violated, will you go to the court based on this judgment that it is already recognized by the Supreme Court?
Yes, ma'am. Right to privacy, for violation of right to privacy, we can do.
Okay. So, okay, I have another question. I'm sure you all must have been, you know, read a lot about that access to justice. सुना होगा ये टर्म आपने, अब तो आप दोबारा इंटरव्यू में अपेयर हो रही। तो मुझे ऐसे 3 रिफॉर्म बताइए जो आपको लगता है एक्सेस टू जस्टिस जो है इंश्योर करेगा सबके लिए, ऐसे 3 रिफॉर्म
Ma'am,
बताइए।
yes, ma'am. Ma'am, the first was that we have now the National Legal Services Authorities Act of 1987. Ma'am, second is that initially the protection of Section 304 could be availed against trial in sessions court only, but now it has been extended to all. And third, ma'am,
Section 304 of which act you are talking about?
CRPC, Criminal Procedure.
Okay.
And ma'am, third thing is that many safeguards have been given to the accused persons also, like Section 41A to 41D and 55A, that is protection to accused. These are the reforms which have been made.
अच्छा, तो ये तो आप सारे मुझे वो वाले रिफॉर्म गिना रहे जो ऑलरेडी एग्जिस्टेंस में हैं, जो लॉ में है, दिए गए हैं। आपको क्या लगता है कि कुछ आपको लगता है कुछ एड ऑन की जरूरत है, कुछ रिफॉर्मेशन की जरूरत है जो आपको लगता है एक्सेस टू जस्टिस बेटर वे में इंश्योर करेगा? अगर मैं आपसे एक सिंपल क्वेश्चन पूछूं कि क्या एक्सेस ऑफ जस्टिस सबको है इंडिया में, आपको दिखता है प्रैक्टिकल, मतलब आप बोल रही है कि आप बिहार की जज बनना चाहती क्योंकि यू बिलोंग फ्रॉम बिहार, तो आई एम श्योर यू मस्ट बी अवेयर अबाउट योर सराउंडिंग सिचुएशन। सो आपको लगता है सबको मिलता है एक्सेस ऑफ जस्टिस?
Ma'am, there may be some situations in which more reforms are to be needed, more facilities are to be given to the people who are downtrodden. Like we have frequently we are seeing the problem of mob lynching. That is a situation in which some works has to be done. And secondly, ma'am, this is in limelight also, girls age of marriage, that is to be implemented in a better way so that girls also can have more opportunities for education and then to stable them financially as well, and then to proceed towards marriage in all these things. And these are the things where we have to work.
Okay, thank you. Now I give the floor to Rama ma'am.
Thank you so much.
So प्रियंका, आप क्रिमिनल प्रोसीजर कोड का आपने काफी जिक्र किया, इट मींस आपने क्रिमिनल प्रोसीजर कोड को काफी टाइम दिया है।
Yes, ma'am.
ऑप्शनल क्या थे आपके?
Ma'am, in optional I have family laws, contract and TPA.
फैमिली लॉ, कॉन्ट्रैक्ट एंड टीपीए। सो फैमिली लॉ अगर आपने पढ़ा है देन डेफिनेटली आपने मुस्लिम लॉ भी कायदे से पढ़ा होगा। सो अकॉर्डिंग टू यू, हु इज मुस्लिम? मुस्लिम पर्सनल लॉज पढ़ते हुए हु इज कंसिडर्ड एज मुस्लिम?
Ma'am, a person who has faith in Islam is called Muslim.
Faith in Islam, okay.
Yes, ma'am.
And मुस्लिम पर्सनल लॉ में आप अगर कोई महिला है, मुस्लिम महिला, और डाइवोर्स के बाद वो कितने दिन तक मेंटेनेंस क्लेम कर सकती है?
Ma'am, in Muslim personal law, initially it was that she can claim maintenance from her ex-husband for iddat period only. But now, after the landmark judgment of Honorable Supreme Court on Muhammad Ahmad Khan versus Shah Banu Begum, 1985, the Honorable Court held that it is the right of the Muslim female who has been divorced that she can claim maintenance even after the iddat period, and until and unless all the arrangement for her maintenance has been made by the husband. Okay.
क्या ये आपके अहमद खान के जजमेंट को ओवररूल करने की इंटेंशन से क्या कोई लॉ भी पास हुआ आफ्टर 1980?
Yes, ma'am. It was the Muslim Women Dissolution Rights on Dissolution of Marriage Act 1989. 1986. 86, yes, ma'am.
1986. So वहां तो बिल्कुल लिख दिया कि ओनली विद इन इद्दत पीरियड टर्म। अब 1985 में ऑनरेबल सुप्रीम कोर्ट ने कहा कि मुस्लिम वाइफ कैन टेक मेंटेनेंस इवन आफ्टर, मतलब उन्होंने कहा कि मुस्लिम वाइफ इद्दत टर्म वाज नॉट यूज्ड in that case. Actually, Honorable Supreme Court held that कि Muslim wife can take can take maintenance under section 125 of Criminal Procedure Code because it's secular provision. और उसके बाद 1986 में आया और वहां पर उन्होंने लिख दिया within इद्दत period. So मेरा क्वेश्चन ये है कि 1986 एक्ट आने के बाद क्या सुप्रीम कोर्ट ने इसको इंटरप्रेट किया? What was the interpretation within iddat period by Honorable Supreme Court?
Ma'am, iddat period means that period interpretation which was given by the Honorable Court. It was that not only those 3 months, but until and unless the arrangement for her maintenance has been done properly by the husband, it shall be deemed that iddat period is continuing.
Very good. मतलब इस बार आपने काफी काम किया है केस लॉ से. Very good.
And ma'am, one more important case on this was Daniel Latif versus Union of India. In this also the judgment was reiterated by the court.
ठीक है. Very good. Okay.